Now, to what was the major story this week. Senate President Bukola Saraki in a face-off with the Code of Conduct Tribunal. Let's go straight to the court.
The Code of Conduct Tribunal was filled to capacity as lawyers, friends and associates of Senator Bukola Saraki stormed the tribunal in solidarity. The anticipated appearance of Senator Saraki, however, generated a lot of argument as the prosecutor and defense counsels exchanged legal fireworks.
My lord, the rule of law will have to be maintained. He gave an undertaking that is going to produce him today. And that is why I urge my client not to arrest because of the undertaking by senior counsel.
On Friday, I intervened at a point to say that I would produce the accused on Monday, yes.
That's today.
I got a bit confused.
Okay.
You did not rule on it. You said it was noted.
Beyond challenging the jurisdiction of the tribunal to hear the suit, lawyers to the Senate President challenged the composition of the tribunal.
More fundamental issues have come up. Now, indeed, when I came in on Friday, my first question was, why were you sitting as two members when paragraph 15(1) says 3 consists the tribunal?
The chairman of the tribunal, however, disagreed with the submission of the defense counsel, just as the prosecutor prayed the tribunal not to be swayed by the submission of the defense team.
This issue of the composition of the tribunal has been tested several times to the effect that even though the Constitution stipulates the chairman and 2 other members, but under the Interpretation Act, it also states that the chairman and 1 other member can form a quorum to determine and consider matters before the Code of Conduct Tribunal.
My lord, from day one, they have been holding on to one position of the law. Say, the tribunal cannot even sit because there is no attorney general.
With the arguments for and against the jurisdiction of the tribunal and the composition of its members, the chairman gave his verdict.
The application to stay proceedings in this matter due mainly to the filing of an appeal at the registry of the Court of Appeal is hereby refused. Accordingly, the Inspector General of Police, as we said earlier, and other security agencies are still in order to arrest and produce the accused person tomorrow, the 22nd of September 2015, at 10 a.m. front to answer the charges against him. And that is the order of the tribunal.
Justice Danladi Umar then renewed the bench warrant for the arrest of the Senate President and ordered the Inspector General of Police to produce Dr. Saraki on Tuesday, the 22nd of September 2015. At the resumed sitting of the tribunal on Tuesday, the 22nd of September 2015, and in line with the order of the tribunal, the Senate President, Senator Bukola Saraki, finally made an appearance to answer charges of false declaration leveled against him by the Code of Conduct Bureau. Attempts by lawyers to the Senate President, Senator Saraki, to prevent his arraignment again provoked a legal exchange as the prosecutor accused the defense team of trying to frustrate his trial.
The provision of this Act, that is Administration of Criminal Justice Act, shall apply to criminal trial for offences established by an Act of National Assembly or other offences punishable in the Federal Capital Territory, Abuja. So, my lord, that Act on its own said any court, administrative criminal justice system in Abuja should apply it. It says so. And the only exception is the subsection 2. Say the provision of this Act shall not apply only to court martial. So it's only court martial that say no, we cannot apply it. My lord, your lordship ruling yesterday, a party cannot come and say she will revisit your ruling of yesterday. I'm not agree with it. Reopen argument. That is what the Learned Council has done this morning.
The Code of Conduct Tribunal is never conceived as a court by the Constitution, and no legislation of the National Assembly can empower it to act as a court or dress it with judicial powers, which are only meant to be exercised by the courts created by Section 6 of the Constitution. This conclusion has solved most of the nagging problems yet to be answered in this case. Since the Code of Conduct Tribunal is not a court and has no power of criminal trial, it cannot issue any warrant for the arrest or imprisonment of a person under any guise. In fact, the power given to the tribunal under paragraph 18 of the 5th schedule of the Constitution does not extend to ordering the arrest or detention of any person who contravenes the Code of Conduct.
The legal battle to have the Senate president docked for alleged false declaration of assets was finally laid to rest as the chairman of the tribunal ruled against the defense team.
Mr. Chairman.
But before taking his plea, Senator Saraki speaks on his travails.
I observed that we made reference to some of the good work the Senate has done in the criminal administration. The same Senate was the one that passed the Code of Conduct Bureau Act of 2001 that clearly states in Section 3D that I just want to make these opening remarks to show that I believe in the rule of law. Section 3D says there that if there is a breach of the asset declaration, the Code of Conduct Bureau shall refer the matter to the Code of Tribunal after giving the person an opportunity to either confirm whether those facts are true. And if he admits, the matter shall not be referred to the tribunal. Well, I will now go ahead because I want to explain why, Chairman, I will now go ahead and accept. I just wanted to state that for you to understand as a layman why I'm puzzled why I should be before the tribunal. I thought that the Code of Conduct should have first called me according to the law, because we have been talking here about the new Nigeria. We have been talking about, especially the prosecutors, been talking about Nigeria going forward. Mr. Chairman, this is the first time, and we are all watching, we are before the new world, not before Nigeria. And we all should be seen to do. I will compare myself with the due process.
Senator Saraki pleaded not guilty to all the charges. The prosecutor opened his case before denouncing the Senate president's claim of not being aware of the charges preferred against him.
After the plea of not guilty has been taken, or no plea has been made, the prosecutor may open the case against the defendant, stating shortly by what evidence he intends to prove the guilt of the defendant. Yes. So, my lord, that is I'm expected to do. And also under your lordship's the rules of this court, apart from admission of criminal justice law, yes, I intend to discharge my duty by stating briefly the evidence I want to call.
However, the defense team opposed the opening of trial, saying the 1999 Constitution provides a platform for accused persons to be given adequate time to prepare for their defense.
Section 36(6)(b) says, every person who is charged with a criminal offense shall be entitled to be given adequate time and facilities for the preparation of his defense. He told the tribunal that he was just coming across these charges for the first time. Ruth V. Jacob will tarry a while. Let the Constitution, let him be given adequate time and facilities to brief and instruct his legal team.
Following this argument, the tribunal chairman granted the Senate president bail on self-recognition and adjourned trial to commence from October 21st, 2015.